In 2001, the Federal Court of Appeal heard the case of Australian Video Retailers and Warner Home Video Proprietary Limited. I will be outlining the key facts and the ratio of the case. The applicants to this proceeding, the AVRA, sought a declaration that the respondents, Warner Home Video, made untenable threats to start proceedings over copyright infringement. The respondents cross-claimed a declaration that their copyrights in the relevant DVDs were breached by the applicants. The parties formulated a series of questions to which they sought a declaration of the court. These questions were: does a party who plays a DVD make a copy of the whole or a substantial part of the movie it contains? What parts of the DVD are categorized as programs under the Copyright Act 1968? Is the leasing of DVDs containing the programs without the owner's license a breach of their copyright in the programs? And does a person who plays the DVD, which briefly copies the programs to RAM, make a copy of the whole or a substantial part of the programs? Although it may not seem it, this case was critically important for the development of copyright law, because if Warner's submissions were successful, then any person watching a DVD would be in breach of copyright obligations unless they were specifically loaned the content from Warner themselves. DVD content sharing would become a thing of the past. To resolve point 1, the court looked at the nature of the playback process. In standard DVD players and computers, a fraction of the data will be copied to the short-term memory, or RAM, of the device. This process repeats throughout the movie and consistently overwrites the previously stored data. The court held that the sequential copying of tiny fractions of the film in order to enable playback did not constitute copying under Section 86A. The answer to point 2 required a look at the definition of a computer program under the Copyright Act 1968, Section 47AB. The programs in question were the instructions contained on the DVD, which allowed it to interpret playback commands such as skip or fast forward, as well as to allow engagement with the movie menu. The court held that these commands were programs, but on their own they did nothing, and so the definition of computer programs only applied to the playback instructions. Regarding point 3, it was agreed between the parties that Warner owned the copyright to the programs in question. Under Copyright Act Section 31(1)(d), Warner therefore owned the sole right to lease these programs, unless the programs were not the essential object of the lease under Section 31(5). The court held that the purpose of hiring the DVD was to view the contents, and the programs only facilitated that. They were therefore not an essential object of the rental, and Warner's copyright in them had not been breached. Finally, the court had to determine whether copying the programs to the RAM of the playback machine was making a copy. Similar to in question 1, the court held that this would not be making a copy of the programs unless the playback device had a method of saving and reproducing the programs from the RAM. In summary, Warner sought to have the federal court state that any viewing of a DVD would be held as copying of both the content and the programs used to run it. If successful, Warner and other content owners would be able to prevent anyone from playing any DVD if they were not specifically licensed to watch the owner's content. Thankfully, the judge held that playing a DVD was not copying the content or the relevant programs, and Warner's submissions failed. Thank you for listening.